Crime in Court. My name is Heather, and this is going to be an update on the Delphi case. If you are paying attention to what's going on, we've been reading through all the court filings on this channel and going over what is not necessarily being reported by news outlets. A lot of this isn't even being reported by other YouTubers are kind of scared to touch on the Delphi case in certain aspects. But regardless, I think it's really important that we all are paying attention because Richard Allen could be any one of us, or Karen Reid could be any one of us. It is so easy for the people in power, those in with all the power and that they can possibly possess behind them, the state, the law enforcement, they can so easily take away your rights in the blink of an eye and for very, very little probable cause or lack of. They can still get some kind of warrant in some cases. So, it's very scary that this is happening to individuals. It's been happening to individuals ever since time began, but we have social media now and we can learn from it and grow and learn and do better as a society. That's what I think needs to happen. Learn from the mistakes that society is making and do better. And I think that the criminal justice system has a lot of areas that we could do better. So for this show, the stream, we're going to go over the motion for continuance from Richard Allen. But this is the motion for continuance, and then there's also a motion to continue hearings on all matters currently set to be heard. So we'll read both of these. We'll read the judge's order. We'll read through also a motion to vacate the safekeeping order and one more that I threw in here for good measure, a verified petition for public funds. They are asking for they are asking for the court to authorize more funds for the defense. All right, so let's begin. Let me shrink myself. All right. All right, so let's begin. We are reading the motion for continuance. Comes now Attorney Bradley A. Rosie and respectfully requests that this court continue the hearings that are set on May 21st, so this is coming up, May 22nd, May 23rd, regarding Richard Allen's purported confessions and the admissibility of communications between the accused and the state-appointed psychologist. In support of said motion, counsel states as follows. Number 1. On the 11th day of April 2024, Defendant Allen filed his motion to suppress statements. Said motion is scheduled to be heard in conjunction with various other matters between May 21st and May 23rd in the County of Carroll, State of Indiana. Number 2, on the 8th day of May 2024, the state of Indiana filed a request for pre-trial ruling on admissibility regarding communications between Defendant Allen and his assigned psychologist. Said motion is currently scheduled to be heard in conjunction with various other matters between May 21st and May 23rd in the County of Carroll, State of Indiana. So they had this meeting or this hearing, rather, scheduled from May 21st through the 23rd to discuss several outstanding motions. They, because they recently had to Richard Allen had to waive his speedy trial rights because basically Gull forced his hand because it was either you can complete your case in the manner of like 2 days, maybe, if the state gives you that much. Or because she only scheduled, I think, like 3 or 4 weeks, something for the trial, this is going to be a long one. It's going to be a long trial. So, and she never even asked anybody like how many weeks they needed and didn't take that into account and didn't take into account how long jury selection could take either. So she really forced their hand. That's my dog. He moans like an old man when he sits down. He's starting to become an old man. My old man, Dexter. Anyways, so yeah, so they have this hearing scheduled and because well, originally they had to waive his rights because we would have been in trial already for the 21st. So they kept, I think, the dates and then made it a hearing or something. I don't know. I don't remember all the details, but they had so many outstanding motions to go over that was going to be part of it was this motion to suppress his confessions or statements made and some other things. I can't remember it all off the top of my head. And the state had some things too. They wanted to basically cut the defense's ability to use a third party culprit defense or any kind of Odinist ties or any kind of anything. Talk about like the theory, basically the strategy that they've been looking at this whole time, the theory that they've been looking at for their case to get their client off from these charges. The state is trying to cut them at the heels and make sure that they can't talk about those things during trial. So that was something that would be ruled on at this hearing, and we kind of know how Gull rules. So we know that she's just going to grant that and totally take away some more of Richard Allen's rights. So, anyways, number 3. The defense has recently conducted discovery in the form of a deposition of Dr. Monica Walla, the psychologist assigned to Richard Allen at the Westville Correctional Facility. The deposition commenced on Wednesday, May 8th, 2024, and has yet to be concluded due to time constraints. The parties are in the process of scheduling the remainder of the deposition, which is likely to take place in early June of 2024. Number 4. So we're going to talk more about this, but let's keep reading. All right, so number 4. There were questions posed during the deposition that were not answered by deponent Dr. Walla at the direction of her legal counsel. Her legal counsel is telling her, don't answer that. So the defense moved to certify these questions and therein preserved the right to seek the court's intervention in obtaining answers to the certified questions. Number 5, additional time is necessary to not only conclude the deposition, but to attain a certified transcript that might otherwise be used as evidence in the hearings on both parties' motions. This could assist in shortening the presentation of evidence regarding said motions. Number 6, Attorney Rosie has reached out to the state of Indiana, who does object. Of course they do. They do object to the request to continue as to the motion to suppress and as to the state's request for pretrial ruling and admissibility, both of which relate directly to Dr. Walla and her relationship with the accused. So what did Dr. Walla do? I want to know. Number 7, Defendant Allen respectfully requests that this court issue an order containing the hearing on Defendant Allen's motion to suppress statements and the state's request for pretrial ruling on admissibility and reset the matters on a date and time convenient for the court and as requested by the parties. So please, let's continue this hearing. Let's reschedule it for a later time. We need to look into this Dr. Walla thing and why do we not have some answers from her? Why did she refuse to answer some questions? It's a good question. So if you look at the thumbnail that I created, I actually found some images of Monica Walla's presence on social media. I don't know if this is verifiably her, but it seems to be the case that this might be her. So, Monica Walla, member of Delphi Unaliving's Drama, Gossip, and Facts since August 2023. I'm sorry, 2022. So that was, she's been following that Facebook group. Another one that she was following is the Delphi Unaliving's Case Discussion and Fact Checks since December 21st, 2021. And then this other image on your far right is it was a post from somebody in that group, the Delphi Unaliving's Drama, Gossip, and Facts. And someone stated and tagged her saying, anyone think it's super inappropriate for a treating psychologist who may be a witness at trial as a member of this group and others? So she is, like I said, multiple social media groups, pages, Facebook, wherever. I don't know. There were multiple places where instances of her name following groups regarding this case on social media. So it wasn't even just these three, there were more, but that's just the ones that I put in the thumbnail. So, sorry, I just wanted to make sure that you guys could see that. All right, so let's move on to the motion to continue hearings on all matters currently set to be heard May 23rd, 21st through the 23rd. So the same hearing comes now the accused, Richard Allen, by and through counsel Brad, Rosie, and Andrew Baldwin, he didn't put his name, and Andrew, and moves this court to continue all pending motions currently set to be heard on May 21st, 22nd, and 23rd. In support of said motion, the accused states the following. Number one, following a brief hearing on May 7th, in which the jury trial in this matter was continued from the 13th until October 14th, 2024. At that same hearing, the court set several pending matters for hearing on May 21st, 22nd, and 23rd. So, like I said, on the 7th was their pretrial. The 7th was like their pretrial hearing, and then that's when they were basically forced to do it at a later time because she didn't allot enough weeks for both sides to put on their case. So, and she didn't ask, and I think she did it on purpose. All right, so did I read that? At the same hearing, the court set several pending matters. Okay. Number two, during that May 7th hearing, the accused's counsel indicated that they would be filing a motion to disqualify Judge Gull, and at that time had a prepared motion that they intended on filing that day. So on the 7th, they were ready to file a motion to disqualify Judge Gull. 3. However, certain issues have arisen both during and after the hearing which have caused defense counsel to add to the motion that the defense had prepared. So they needed to add more to it. Number 4, the defense has therefore been adding to that motion, as well as re-editing the motion, taking additional time to prepare said motion for filing. Like saying, we got you. We are taking notes. We are not going to stand for this anymore. We're going to hold you accountable to your actions, Judge Gull. Number 5, also, the new motion required Richard Allen's signature, and because Richard Allen has been moved back to Wabash Valley Correctional Facility, it is logistically difficult for Richard Allen to review the document and sign the document so that it comports with the legal requirements of a request for disqualification. Number 6, Richard Allen has just signed the documents as needed, and therefore the defense files its motion to disqualify at the same time as this motion to continue next week's hearing. So we've asked you to continue the hearing. We're asking you to continue all of the proceedings, all of the topics that we're going to be talking about in this hearing, and we're going to file another motion to disqualify you because you are not treating us fair. Number 7, as the court is aware, at the time Richard Allen petitions this court for change of venue from the judge, this court will be without jurisdiction to do anything other than rule on the motion. So basically saying now that this motion to disqualify has been filed, you can't rule on anything else until you rule on the motion to disqualify. And it is probably one of the dumbest rules in our judicial system. If you want to have a judge removed from your case, you want them to recuse themselves, you can ask them to, file a motion to have them recuse, file a motion to disqualify, whatever it might be. But the person that's going to listen to your arguments is usually the judge that you're trying to get rid of. In certain states, in Indiana, that is the case. And I believe, um, I don't know, I'm not going to speak out of turn. I know in Indiana, they have to seek a an answer, seek a judgment from the judge that they're trying to remove, which it doesn't make any sense. It should go to an impartial judge that has no information about the case. Anyways, all right, so number 8, additionally, the defense is requesting Judge Gull to issue findings of fact and conclusions of law if she issues a ruling denying the defense motion to have her disqualified. So, as we've been seeing with Judge Gull, her favorite thing to do is deny without hearing. And that is what she has continually been doing to the defense, not giving them any legal grounds, any legal reason as to why she is just disqualifying them from, or denying them for their hearing or whatever. Like they've asked now 4 times for the Frank's motion and she still won't give it to them, the Frank's hearing, which is to hear the evidence on the Odinism. They've been asking since September of last year to get to get a hearing, and they were supposed to go to trial in January of this year. So shows how she's really pushing that off. And so that's what they're asking for is if you're going to deny us a motion, give us facts and conclusions of law. That is what you're supposed to do as a judge. You're supposed to rule based on other judges' rulings in the past. So you might have to do a little legwork and cite some things in your judgment, but that's what you're supposed to be doing. All right, so number 9, therefore, Judge Gull will not be able to conduct a hearing or rule on any matters until she has reviewed the motion to disqualify and entered findings of fact and conclusions of law. So, yeah, because last time she totally ignored them for all of their motions and just goes and sets sets hearings for Nick McLeland whenever he wants one against their contempt. So, yeah, it's just BS what she is doing to them. Therefore, number 9, Judge Gull will not be able to conduct a hearing ruling on any matters until she has reviewed the motion to disqualify and entered findings of fact and conclusions of law. I love it. I love it so much. I read it twice. All right, number 10. Additionally, on May 15th, 2024, the state of Indiana just turned over a new phone extraction that had been conducted this past weekend. So, I'm sorry, what? You were supposed to be in trial and um or shortly going to trial, and here we are with, or no, they were supposed to have started the 13th. So yeah, right? The 13th, I think. All my dates are and my cases are blurring, but yeah, they would have already been in trial already, and the state is still turning over discovery to the defense. They just did a new phone extraction. From who? That's very interesting. Number 11, the defense received possession of that new phone extraction less than 1 week before the motion in limine hearing was set and needs more time to review the phone extraction data. So we need to review this, lady. Number 12, based upon a quick review of the phone extraction, it is likely that the defense will use the new phone extraction as part of its evidentiary presentation, arguing against the prosecution's motion in limine to not discuss third-party suspects, as it appears that the new phone extraction provides favorable evidence for the defense. But the defense needs additional time to review the entire phone extraction in order to be prepared to argue against the prosecution's motion in limine. So, prosecution has all these motions in limine where they want to keep things out and keep, that the motions in limine are basically like, this is what we want in during our trial and this is what we want out. These are certain things that we want to argue before trial, or set stipulations, come to an agreement on before going to trial. So since they were just about to go to trial, they had put forth their stipulations or whatever, their motion in limine. So that's what this is in regards to. But the defense needs more time to review this phone extraction because it's going to be something that they can argue regarding that motion in limine. So I wonder if it is Fig Solves, maybe. We got a Fig Solves who the DA potentially, or someone from the DA's office, someone from Judge Cannoni's office is leaking information before it's even been made public to Fig Solves, who is, I think he's a YouTuber, or honestly, I don't know. He's some true crimer. All right, so where was I? Additionally, the witness who extracted the phone data last weekend has indicated that he will be issuing a report on his findings as well as investigating matters identified by the defense that the defense believes provides important information concerning third-party suspects. So thank you for giving us more time, Judge. Now we're going to make our case even stronger and come in with even more evidence that points to someone other than our client. Number 14, the defense would therefore request that at a minimum, the hearing on the motion in limine be rescheduled until after the aforementioned report is filed, as it would be judicially economical to hear all the evidence for the motion in limine at one time in one hearing, and would additionally prevent the court from prejudging the evidence presented until all the evidence can be presented at the same time in the same hearing. I mean, that's a great argument, but will she do it? We'll find out. All right, number 15, the trial has been continued until October 14th, which should provide an abundance of time to find new dates to conduct said hearings. 16, since Judge Gull cannot rule on any motions until after she rules on the defense motion to disqualify, it would be judicially economical to continue the matters scheduled for May 21st through the 23rd until after Judge Gull has a chance to review the motion to disqualify and issues findings of facts and conclusions of law. That's a big deal because she has really not been doing that at all for these guys. Should she deny the defense motion to have her disqualified as judge on the case, 17, the prosecution has been contacted and does object to this request. Of course they do. Wherefore, the accused, Richard Allen, files his motion to continue the hearings on all matters currently set to be heard May 21st through the 23rd and all other just and proper relief. So we also got I added that to here. Defendant's motion to vacate safekeeping order. Hold on, that's really, that should go with this. So, oops, not that. We'll get to that. So let's read through what Judge Gull says regarding the continuance. Of course, you can't just come out and say, I'll give you something or be positive in any way. She just comes out and says, defendant's motion for continuance reviewed and denied in part, not like partially approved or partially granted, whatever the wording is. I don't know. The court scheduled this hearing at counsel's request, who all indicated that they would make those dates work on their respective calendars. The court will conduct hearings May 21st through the 23rd on defendant's motion to suppress a second statement filed April 15th, 2024, the state's objection to defendant's motion to suppress filed the 15th, the defendant's motion to compel and motion for sanctions filed the 23rd, the defendant's motion to vacate safekeeping order filed May 13th, the state's motion in limine. So see, these are just all, she's listing all of the different filings that still have to be ruled or argued, and the defendant's response to the state's motion in limine. As defendant is not prepared to address his motion to suppress filed April 15th and the state's motion for admissibility, those matters are continued and will be reset at the conclusion of the hearings. So they're not going to argue a couple of motions, but for the most part, they're probably going to argue all of the other ones. All right, so that's what she decided for the continuance. Let's move on to the defendant's motion to vacate safekeeping orders. He's currently under safekeeping orders, which means Richard Allen means that he is being protected by being in solitary confinement 24/7. Maybe it's like 23/7. Sorry. They get like an hour out of their little box. And he's been not doing mentally well, just because of mistreatment and being in isolation and whatnot. So this is a motion to vacate that safekeeping order. This is why he's in this Westville correctional facility, why he went to or now he's in Wabash, but he was in the Westville correctional facility, which is where Monica Waller came from, the psychologist that we still haven't even gotten into all of that. But yeah, so anyways, the motion to vacate the safekeeping order would mean that he could come back if she granted this motion, then he could come back and stay at county jail and be much closer to his attorneys, and it would just make sense if that's what she would do. But we don't know how she's going to roll. We can assume or presume. All right, so comes now Richard Allen by counsel and respectfully requests the court vacate the safekeeping order dated November 3rd, 2022. So that's how long this has been in place. He's been in solitary for over a year and a half, or just about a year and a half. In support of his motion, Mr. Allen states as follows. On November 3rd, the then Sheriff of Carroll County, Tobe Lesenby, filed his request by the Sheriff of Carroll County, Indiana, to transfer inmate from the custody of the Sheriff to the custody of the Indiana Department of Corrections for safekeeping. Number 2, on that same day, an order was entered finding that Mr. Allen was an inmate awaiting trial and was in imminent danger of serious bodily injury or death, or represented a substantial threat to the safety of others. Number 3, Tony Liggett is currently the sheriff of Carroll County. Number 4, on May 3rd, 2024, counsel for Mr. Allen deposed Carroll County Sheriff Tony Liggett. Number 5, during his deposition, Sheriff Liggett testified as follows. A. I did not have a problem with him, Richard Allen, going to Cass County. My problem was going to be transport. B. I never had a problem with him, Richard Allen, staying in a county jail. C. Sheriff Liggett has since made arrangements with the Tippecanoe County Jail to house Richard Allen during the trial. D. When asked if Richard Allen could stay at the Cass County Jail, Sheriff Liggett responded that he does not care where Rick Allen is as long as it does not become a manpower issue for him. 6. Sheriff Liggett also testified that the Indiana Department of Corrections does not want to transport Mr. Allen. Number 7, there is no current evidence that Richard Allen is in danger of serious bodily injury or death, or that he represents a substantial threat to the safety of others as required by IC, whatever rules. Number 8, the transportation of manpower issues originally surrounding the detention of Richard Allen in a county jail have been resolved. Number 9, counsel for Richard Allen respectfully request that the court vacate the safekeeping order in this matter and order that Richard Allen be housed in either the Cass County Jail or the Tippecanoe County Jail until the trial of this matter. Wherefore, Richard Allen, by counsel, respectfully requests that the court vacate the safekeeping order and for all other just and proper relief in the premises. So that is very interesting. I feel like they've been working on this for a while to get him to make these arrangements or to make these arguments so perfectly and to make it so that they knew and they had to make the preparations themselves, I'm sure, going to the Cass County or Tippecanoe and making sure that they could accommodate him during the trial. So that's pretty awesome that he's got some really good lawyers on his side, I think. All right, so finally, so the defendant's motion to vacate safekeeping order is going to be set now for May 22nd at 10 a.m. So that's going to be during their May 21st through the 23rd hearings. She'll hear that then. So that's good because then they can try to get Richard Allen moved to county jail, which would be more convenient for all, better, hopefully, accommodations for Richard Allen, and not being in isolation would really be helpful for his mental health, I'm sure. All right, so verified petition for public funds comes now. Richard Allen by counsel, Andrew Baldwin, Brad Rosie, and Jennifer Auger, and respectfully requests that this court authorize the expenditure of public funds to reimburse attorney Jennifer Auger for legal services rendered on behalf of pauper defendant Richard M. Allen. In support of said petition, Andrew Baldwin and Brad Rosie swear and affirm as follows. Richard Allen was previously determined to be indigent and is currently represented by public defenders Rosie and Baldwin. The court previously approved a limited appearance by Jennifer Auger for the purpose of matters related to the service of process and future depositions of Federal Bureau of Investigation agents. What? They're deposing FBI agents associated with the investigation and prosecution of Richard Allen, and assist Mr. Allen and his legal team with digital forensic issues surrounding the investigation and prosecution of defendant Allen including but not limited to conducting discovery, depositions, and courtroom examinations regarding this case. 3, in order to prepare for the above activities, Attorney Auger has intimately familiarized herself with the facts of the case. 4, the volume of discovery and evidence that exist in this case is unprecedented and has been articulated in various defense pleadings previously filed with the court, of which defendant Allen incorporates herein by reference. The prosecution has previously identified 26 terabytes of data that it has discovered to Mr. Allen's attorneys, which is scattered over 14 hard drives, e-discovery, flash drives, and DVDs. To give the court some reference, if the 26 terabytes of information were one-page documents, that would equate to 60 million documents. Alrighty, that's a lot. This includes over 60,000 FBI notations on their Orion system. To be fair, some of the data, so do they have FBI notes on this case? Like, I'm sure the FBI got involved because juveniles and sometimes they just do get involved. I know a lot of times, like their state law enforcement will get involved when it's children or something like that. So, um, FBI, I don't know why or when they came in. Like, when did they come into play? I don't know when we started talking about the FBI in this, but is the FBI investigating this case? Is the FBI investigating the people who investigated this case? Potentially? They should have information if they're looking. They could easily get the information that Allen's attorneys can't. To be fair, some of the data disclosed by the state includes videos of interviews, which reduces the amount of documents provided in discovery. Nonetheless, the amount of discovery is incredibly large, and the defense believes this requires 3 attorneys to review. Number 5, much of the data is not saved in any description fashion, i.e., files named doc, followed by a series of numbers. Are you kidding me? Are you kidding me? How they do it? They just sign or number a document by or name it doc number 125678. And therefore it is unclear what documents are included in what files. As a result, Attorney Auger has reviewed numerous unrelated documents in order to prepare for the cell phone forensics. Number 6, while the prosecution has had much of the information disclosed to the defense since February or March of 2017, the defense only began receiving the disclosures on January 30th. Number 7, there is some carryover between forensic witnesses and other witnesses. 8, additionally, there are approximately 16 expert witnesses identified by the parties, including in the areas cell phone forensics, geofencing, odonism, ritualistic, life ending, spatter, DNA, ballistics, psychology, psychiatry, false confessions, and forensic pathology. Number 9, the parties have identified over 185 witnesses who may testify at the trial of this action. While the prosecution previously stated they were paring down their witness list, they have not excluded any witnesses from their list, and therefore the defense must prepare for all witnesses disclosed. So the state's not helping us any by making us prepare for every single witness. Frustrating. All right, so number 10, the state of Indiana has 3 attorneys in this matter, as well as the assistance of the Indiana State Police, the U.S. Marshal's Office, the Federal Bureau of Investigation, Delphi Police Department, and the Carroll County Sheriff's Office. Mr. Allen's defense should be entitled to parity in his defense. So to similar amount of resources behind him, although that'll never happen because um, because state of state police, marshal's office, all of that is for finding criminals. Anyways, all right, so number 11, due to the volume of discovery, which continues to be disclosed up until just this past week, Attorney Rosie and Baldwin have very limited time and therefore need assistance with discovery, preparation, and trial of this matter. 12. Attorney Auger will be present at trial to conduct direct examination and cross-examination of experts in the field of cell phone forensics and geofencing, and the defense would like her assistance with additional witnesses and preparation. So she's going to be their phone forensics person. She's going to dive into all that kind of info. She must have some knowledge or, experience in that area already. So she'd be more knowledgeable in that regard to ask those experts. 13. Attorneys Rosie and Baldwin believe that this is in the best interest of defendant Allen and in the interest of judicial economy that Attorney Auger assist defendant Allen and Rosie and Baldwin and request that the court order the Carroll County auditor to reimburse Attorney Auger for costs associated with her services at the same hourly rate as that which attorneys Baldwin and Rosie are currently being compensated. Said reimbursement would be contingent upon the court's pre-approval of Attorney Auger's submitted invoices. Number 14, defendant Allen has been consulted and concurs with attorneys Baldwin and Rosie's request to add Attorney Auger's unlimited appearance in this case and for the purpose of references herein. So they're basically just saying, please, I mean, our guy doesn't have a fair shake. You've got all the power on your side. Just give us this attorney, please. She's going to help us in the phone forensics, and she's going to help with preparing witnesses and questioning witnesses. And we've got to prepare for all of these witnesses, Judge, because the state won't take any of them off the list. So we have to be ready, as any good defense attorney should. So it's going to be a wild couple of months until October, at least for those three attorneys. Hopefully, Judge Gull decides to let Jennifer Auger on indefinitely, unlimited, and pay her too, because there's been some talk about how Judge Gull hasn't been making the payments timely to Rosie and Baldwin or Jennifer Auger. So who knows? Hopefully, Judge Gull will just get recused, or will, she's not gonna, I don't think she's gonna disqualify or recuse herself. But I think for due process, they need to put that motion, they need to put that motion forth to Judge Gull. She's probably going to deny it, and then they can finally appeal it, do an interlocutory appeal, or appeal to the Supreme Court and say, can you remove her now, please? We asked you once, and look what she's doing still, and worse. So hopefully there is some other step that these attorneys can take once Judge Gull says, no, I'm not leaving this case. Although I don't know why she would want to stay on it, because honestly, it's got to be stressful. She probably doesn't want negative attention on her. So I would think, by the way that she's ruling, I don't understand why she's doing it. But I guess she doesn't care about public perception or anything in that regard. So I really don't know. I hope that there are some other steps that Baldwin and Rosie can take in order to get her removed completely from this case. I believe she was like specially appointed for this case, wasn't she? Because of the nature of this case, I want to say. So who appointed her? How did she get here? And why won't she leave? How did you get here, Judge Gull? And why won't you leave? That's my question for her. So hope you enjoyed this episode. Or stream, I will be doing multiple streams on Delphi because many, many documents have dropped. So make sure the notification bell is on. Be sure you like this video, and I will see you guys in the next one. Take care, and thank you so much for watching. Bye now.
If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.